Commissioner Malema.
No, thank you very much. Good morning, CJ, and good morning, Judge. Just a follow-up. The CJ asked how many reserve judgments do you have? You said 5. But I saw somewhere there Nadel said 7, so I just wanted to reconcile that.
Yes, thank you, Commissioner Malena, and you're quite correct. There is a discrepancy in the comments. The GCB indicated that it was 5 at the time that I submitted my form, and I think it was Nadel pointed to the correct number at that time, which was 7. So that was an error in the GCB's comment, I think. So the correct position was at the time that I submitted my form, there were 7 reserve judgments. But as I sit here now, none of those are outstanding, and there's only 1 new reserve judgment that's still within the 3-month period.
You cleared them for this purpose?
Sorry?
You cleared them for this purpose?
I always clear my judgments.
Not they were outstanding, not so long ago, and before you come here, they are all cleared.
Well, I'll clear all of my judgments. I will pick up, I have quite a heavy role, and I will be accumulating judgments all the time. So the approach that we need to follow is always to clear our judgments.
What is your take on the current constitution? Does it allow expropriation of land without compensation?
Commissioner, I do need to be guided in some measure. I would like to answer that question, but I do need to be guided in some measure by the Chief Justice, because I need to be cautious about it, because it's an issue that can come before us. So the approach I adopted in my first interview was to indicate that I'm comfortable approaching it at a high level, but mindful that before I can ever make a decision on an issue of that sort, I would need to fully hear argument about from both sides, because it is a live issue and it will come before us. Chief Justice, are you comfortable with me proceeding?
Yes, in the same way you did the last time.
All right.
From
Thank
a high
you, Chief
level.
Justice. At a high level, yes.
Yeah.
And by prefacing what I say with that, I couldn't decide that without fully hearing argument. So my view, thank you, Commissioner. I mean, it's obviously a very important question that matters to a lot of South Africans, and there are, and it is going to have to be squarely decided by courts in one would hope in the relatively near future. As I see it, there can be no real debate about whether the Constitution properly applied permits of nominal compensation. I can't see how that's debatable, because even if one looks at the factors that are set out expressly in Section 25(3), even just by applying a mathematical formula, for example, if you look at the extent of state subsidy that may have been given to a white farmer in the past, and then you look at market value, you can easily come up with a calculation that gets you to a zero balance. I think the more difficult debate is whether properly construed, the Constitution permits of 0 as opposed to nominal compensation. And there I've read different arguments, and I don't know the answer. I'd really need to hear argument on it. But I do think that there are, given our history, there are compelling reasons that the Constitution fully embraces why there should be departures from market value compensation.
So will it be within the Constitution?
You're on a bad question, and the agreement was 2 per commissioner.
Huh?
The agreement among the commissioners, which you know, it dates back even before I started chairing this body, is that commissioners ask only 2 questions. 2 questions per commissioner per candidate.
Oh,
yes.
Judge Mlambo didn't ask 2 questions. I was here. I listened to him. He didn't ask 2 questions. Unless there's some right reserved for other commissioners. I'm prepared to leave this question here, but in reality, if you go back to check the record, JP Mlambo did not ask.
Commissioner Malema, we are wasting time debating how many questions should be asked. Just ask your question and keep it as brief as possible. But that does not mean I'll be lenient with other commissioners.
Thank you. No, I just wanted to ask, will it be unconstitutional to pass a bill which allows the state to be a custodian of the land with the fully land use rights guaranteed, that no one loses anything, the state owns the land, and whatever remains, whatever is on the land, remains in the pockets and the hands of those who are using that particular land, like we did with the minerals and like we did with water. What's your take on that?
Thank you, Commissioner. I have to be I'm aware of the political debate, and I've followed the political debates, which I find, they're important debates, and they speak to matters that are very important to South Africans. I don't know the answer, and I haven't heard, to be honest, I haven't engaged it in a legal sense. I've thought about it in a political sense. So I haven't, the truthful answer is I haven't sat down and tried to work it out from a legal point of view. But I do think that if one just thinks about it from a, as one, and I think there may be differences. I'm just not thinking aloud, which perhaps I shouldn't do. The simple answer is I don't know the answer. I think state can, at least in some cases, be a very useful modality to secure justice as a policy position, but that's just my own sense. I haven't thought through the legalities.
Thank you, CJ.
Commissioner Marumo Achai.
Thank you very much, CJ. Good morning to you and to all the commissioners. Good morning, Judge Cowen.
Good morning, Commissioner.
I've heard your vision and some of the initiatives and challenges that you have outlined. But I just want to pick your brain in as far as, yes, we understand that there is insufficient judicial resources and some of the challenges that you have identified. And you have outlined that currently there's a difficulty in terms of enrolling matters. In other words, there is a backlog and those matters need to be dealt with. What discussions, if any, in the leadership core of the court have been had to ensure that strategies are put in place that even with limited resources, those kind of cases are disposed of in order for us to realize the constitutional goals? Thank you very much, CJ.
Thank you, Commissioner. And this is a topic we discuss almost every day. It's a priority for us. Anyone who comes to our court can see that there's a problem in enrolling restitution cases and labor tenancy cases. The strategies we are already adopting and which I think are showing results are well, the primary judicial strategy is to case manage. So we've been doing this now for several years. This project had started even before, or started around the time that I arrived on a permanent basis. So cases at this stage, all cases from 2016 that arrived and referred to the court in 2016 have been flagged, and all those files have been pulled, are being allocated to judges for case management. So you'll find that, so if you were to look at my diary and you were to look at my role, you will see that I have far more case management hearings in the land court than I do have actual hearings. I am hearing restitution matters, and I'm one of the judges that have, because of the time I've already been there, I've been able to get matters to the point of enrollment. So my role is getting fuller. But for a new judge who arrives, until you can case manage to the point of enrollment, you're not going to get matters on the roll. So it's a critical tool. And so we're developing practices in the court around case management. The JP just last week or the week before, I think it was, ensured that we had internal discussions around best practices for case management so that we can learn from each other. And so that we can, we need to develop best practices for case management. And it's different to the High Court space because we're often dealing with unrepresented, marginalized rural litigants. So for example, one of the strategies we use is, one of the first things you look at is there a problem with representation? And if there's a problem with representation, we literally pick up the phone Legal Aid South Africa and say, please come to this meeting, and they come. They're working in a very cooperative basis with us. We've got good relationships. They'll come to the case management meeting, and then we will make sure that the parties are represented. Another strategy is we have a look and try and pick up what are the typical problems in delay. So one of the problems we see often is that there are difficulties with the gazetting of land. So when claims were lodged in the early gazette gazettes were not done properly, and we will make sure, so one of the first interventions will be, has the land been properly identified and has the land been properly gazetted? Because if you don't get that right up front, you're looking at delay. So we identify strategies for intervention, and we do it up front, and in this way we get everyone around the table, we agree on sensible, practical ways to navigate the issues in the case to get it to enrollment as quickly as possible. So it's going to be, and again, that talks to our need for more judges. The JP has been very proactive in getting judges and other judges involved, including retired judges, involved in some of this work. So we are drawing on the resources of our retired AJP, who's able to work in the most effective way, just from a case management perspective. So bring people in, help us case manage these cases just to get them enrolled. So we talk about it every day. Yes.
Thank you very much, Judge. Thank you very much, CJ.
Thank you, Prof. Commissioner Ngueto.
Thank you, Chief Justice. Judge Cowen, you have spent the majority of your time outlining the sort of pragmatic problems of how to get things done in the Land Claims Court, and it's very admirable, your knowledge of the land ecosystem and your knowledge of the processes of the court itself. But there is another role to the position you are going to occupy, which is that of intellectual leadership. So I fear we're not giving you enough questions that are challenging you intellectually, so maybe let me fill that gap. I agree with you fully when you say the government is to blame for the problem of landlessness and land injustice. 100% they are to blame for it. They've dilly-dallied, they've adopted the wrong policies, they've defunded land, they've defunded the Land Claims Court, they've defunded the Land Claims Commission. So every charge in the charge sheet has been established. But I think that the judiciary must also take responsibility for the way in which they have handled the jurisprudence of land. Now, I want to give you 4 examples in which they have constrained the ability to reach the constitutional vision that is outlined in a very ambitious section, Section 25. Firstly, they have adopted a narrow definition of community, which has excluded numerous communities from being able to obtain land justice. And that's purely a jurisprudential thing. There's nothing in the Constitution that requires the judges, particularly of the Land Claims Court, to adopt such narrow constructs to the definition of community. Secondly, they have put restoration as an entry point to debates of feasibility, as an entry point to debates about restitution. And what that means is that you end up with an artificial argument about the feasibility of restoration, which focuses on the financial feasibility of restoration, and without asking whether or not the landowners that own Sentin live here. But you ask the same thing about communities. Are they going to live there? But the owners of Sentin are living overseas, and nobody's asking that question about them. Thirdly, they have used market value as a starting point in the assessment of compensation. Again, it was judges who decided that market value would be a starting point in the assessment. Fourthly, they have found in many cases that people that were dispossessed were in fact labor tenants, and which disables them from claiming fully fledged ownership rights because the judges have decided they were labor tenants. And then finally, they have adopted an approach to land that is sort of common law centric, right? So the debate is land property or not. Now, I've put this to you because out of the judges and the judgments I've read in the Land Claims Court, yours are the most promising, the most radical, and they show the ability to break with the straitjacket of the common law. And maybe if there is any hope, it will be in a lot of the judgments that you have written. So maybe you want to say something about the intellectual challenge of breaking with the tradition in order to give effect to the constitutional vision in Section 25.
How long do I have?
No,
I think 30 seconds.
unfortunately, he has taken all the time that is allocated to the interviewee to answer, because that was anything but one question and nothing close to short, crisp, and concise.
Judge Cowen,
Do your best.
I leave it
Judge
to the
Cowen.
Chief Justice to decide what to do.
Just do your best.
Thank you, Commissioner. And I do think that when I noticed in the preamble to the Land Court Act, Parliament itself speaks about the need for progressive jurisprudence, and I'm interested in that because there seems to be a recognition by Parliament itself that there's a need to shift how we're thinking about land law. And I agree with that at a high level. I think that when I look at the land space, I wonder why it's taken us so long to get to where we are. And I think we do need to shift the ground quite radically. There's so much that one can do, and we are bound by stare decisis, and stare decisis is a principle that is central to the rule of law in South Africa, which is a founding value. So as a lower court, there's so much one can do until matters ultimately get up to the Constitutional Court. So if I may use this opportunity, now that I have the audience, to suggest to the Constitutional Court that there's a critical need to have a look at some of these issues. They really do need to be scrutinized, I think, carefully. The one area where I believe, managed to make some headway is in the area of cattle and grazing. And this is an issue which we canvassed at some length in the previous interview. And I know that in the case, it's the one matter where I have been overturned on appeal. And as I understand it, that case, I don't know what the status of it is, but that there are processes, those parties are seeking to go to the Constitutional Court. So it may be that there's an opportunity coming up soon, whether it's in that case, I don't know what the court will say, but whether it's in that case or in another case, we really need to rethink how we think about cattle and land. And that's precisely because of the connection between cattle dispossession and land dispossession in this country, which what we see in the court is ongoing. It's that colonial legacy of dispossession is ongoing, and that requires full frontal re-examination of the common law and how it applies in the context of land law. The issues around labour tenancy are very troubling as well, and that not only invokes concepts around community and labour tenancy, it also invokes the cut-off date. So the cut-off, everyone knows the Constitution refers to 2013, the date of the Land Act. Especially in the world of labour tenancy, many people were converted through the stroke of a pen to become labour tenants when titling happened in the late 19th century, sometimes without their knowledge. So how we think about, and that can impact in whether one's even viewed as a community. This is a live issue before me now, so I can't go into it in much detail, but the issue of what is a community and how labour tenants are understood in that space it's a deeply troubling question that I believe needs to be looked at closely by the courts. I'm going to have an opportunity to do that now, and I've just heard argument in a matter on that. But the issues that you raise, Commissioner, are obviously they're large issues. I would love to talk about them all day. I don't think I have the space.
We don't have all day.
But yes, I agree that there's real space to shift our jurisprudence into a more progressive jurisprudence.
No, I think that answer suffices for present purposes. It's just whet our appetites enough. Discussion for another time at length. Just to round off on your CV, Judge Cowen, I sold you short because I did not mention the many publications you have under your belt from your other life as an academic and legal practitioner. You've listed 12 publications on diverse subjects ranging from witchcraft to a critique of the draft National Prosecuting Authority Bill of 1997, and of course, which I overlooked, a review on sexual harassment in the workplace. Interesting. Do you still write?
I
Do you have the time?
I have to write judgments. I have to
Indeed.
clear my desk on an ongoing basis. I'm not writing academically at the moment. I'm focusing on my core judicial functions, which are now also including at this stage, at least, administrative functions. So I haven't had the space to write for some time. And I haven't yet found that voice as a judge. So I used to write as a practitioner, which gave me more space to express my opinions. As a judge, you have to be more careful. You can write, obviously, but I haven't yet found that voice, but I hope to do so again at some point in the future.
Yeah, I hope you do too. All right, that brings us, there is another hand, Commissioner Nungonyen.
Good morning, Chief Justice. Good morning to the commissioners. Morning, Judge Cowen. A pleasure to see you.
Good morning, Commissioner.
I'm impressed by your presentation. But the point I would like to raise with you is that in that Macau case, which is a complex case involving Northwest, Limpopo, Mpumalanga, and Gauteng. And all those that were involved there were really impressed, including myself, representing Contralesa. I'm sure you're seeing me for the first time. But the question that I would like to raise with you is how do you really balance the principles underlying customary law as well as those Roman Dutch law? Because in all your judgments, we were all impressed about the manner in which you navigate these things. Thank you very much, CJ.
Thank you, Commissioner. I find the interrelationship between customary law and common law to be one of the most interesting features of our law. And it's quite difficult. And again, it's one of the areas where we need more case law to explain how that works. But I suppose the starting point is the recognition that under colonial and apartheid rule, customary law was not accorded its proper place, and that one of the main purposes, and it was degraded, and it was distorted, and it was in profoundly problematic ways. And I think that the starting point is to see the Constitution as the point at which customary law must be given its proper place. It must it sits alongside common law, but it must be accorded its proper place. And that means that it has to be given far greater expression in how we think about land. That's the space that I'm occupying. Land rights, how we think about communities, how we think about community relationships. So I've been fortunate in my practice because I was exposed to a lot of these disputes, and I spent a lot of time with people hearing about how communities are constituted and how disputes are resolved, and I've learned a lot from what I've seen and from the cases that I worked in. And that allows me to bring that into my adjudication. I think it helps me to ask questions. I don't know the answers to everything, but I think it helps me to ask the right questions.
Thank you, CJ. I have no questions.
Thank you, Commissioner Ngunyan. That brings us to the end of your interview, Judge Cowen.
Thank you, Chief Justice.
Thanks for presenting yourself for this interview.
Thank you, Commissioners. Thank you, Chief Justice.
If you found this video informative, please like, subscribe, and hit the notification bell for more content like this. And as always, let us know your thoughts in the comments below. Until next time, stay informed and stay engaged.